Good afternoon, everyone, to the New Mexico Medical Society Noon Zoom. This is a special two-part series on the new law, the Elizabeth Whitefield End of Life Options Act, also known as Medical Aid in Dying. As you know, the law was passed this year in the New Mexico legislative session after 26 years of work on getting this through. We're very honored to have the bill sponsor and advocate, Representative Debbie Armstrong, the bill author and longtime advocate, UNM Regent and Professor Emeritus of Law, Rob Schwartz, and New Mexico Medical Society Legal Counsel, Nick Audio. They will speak on the legal aspects of this new law. We're happy to say that this session is CME accredited. If you're interested in receiving CE, please put your name and your email in the chat box, and we will send you an evaluation, which you will return, and then we'll send the certificate for you. Next week is the second part of this series, and it will be a clinician panel, and which will include national and local experiences. That also is CME accredited. In the announcement, we asked for any questions that you had prior, and we did receive several of them. The panelists will do their best to address those. There will be time for questions at the end of this, at the end of the presentations. But if you do have questions that come up during, please add them to the chat so that we can make sure that we respond or get back to you afterwards with an answer. I think that's it for introductions. Thank you all so much for joining us, and I will turn this over now to Representative Debbie Armstrong to lead us off.
Thank you, Annie, and thanks everyone for being here and giving us an opportunity to talk about the End of Life Options Act, which was named for a judge in Albuquerque, Elizabeth Whitefield, who passed away during her, before this was able to be enacted. But she was a great advocate. I'm actually going to let, just to let you know, I'm going to let Professor Schwartz go first, kind of to give some context of kind of how we got here and context for the state. I want to then talk about a couple of things we've done differently in this law than in other states. And then Nick is going to go through it in detail, what's in the law, and then we'll be open for questions. So Professor Schwartz.
Much and thank you so much, all of you, for being here today. And my thanks to Annie for setting this up and to Nick for setting this up. I'm going to leave a discussion of the bill primarily to Representative Armstrong, who is, of course, the author of the bill and also the sponsor of the bill and very much the midwife of the bill in the legislature this year as well. And also to Nick, who, as many of you here know, is the expert in New Mexico in translating legalese into ordinary English that reasonable people and thoughtful doctors can understand. So I will leave the details there, and I just want to talk for just a few minutes about context, because medical aid in dying is, of course, new in New Mexico on June 18th when it will become available, but it is not a brand new idea, and it's an idea that has gained steam over the last half century, really as a result of the remarkable medical developments of the mid-20th century. And I'm not going to go over all of those, but it's not just immunizations and antibiotics. Those weren't the only developments of the 20th century. In fact, improvements in the use of ventilators, improvements in dialysis, improvements in other kinds of care, which did remarkable things to medicine last century. Much good, but they also raised some concerns over what had become the general principle behind all of medicine, which was save lives. The first principle was save lives. It's not what the formal first principle, of course, but it was the real first principle, essentially save lives at any cost. And as a result of those wonderful developments, generally wonderful developments, people led longer lives, but not always better lives. And in fact, there were times when people had to lead lives of terrible suffering, or at best joyless lives, lives without what brought satisfaction that made life worthwhile, in part because of the treatment that healthcare providers felt obliged to provide them. And it gave rise to legal questions which had never been addressed before. One of them, and we tend to forget this, but in the mid-1900s, in the 1950s, in the 1960s, in the 1970s, we didn't know as a matter of law whether someone could actually decide to discontinue treatment. We didn't know whether someone could have a ventilator removed. It wasn't clear whether it was ever legal to remove a ventilator, for example, if that would result in the death of the patient. And the law started addressing those kinds of issues. In 1960s, we finally addressed brain death. Brain death wasn't recognized as a definition of death until the 1960s, first through the ad hoc committee at Harvard Medical School, and then through a uniform law that virtually every state, including New Mexico, adopted. In the 1960s and 1970s, we had litigation over whether people could discontinue treatment. Some of you, people my age, will remember the Quinlan case in New Jersey. Can a patient who is not competent, but is in fact being tube fed, have the tube feeding removed? It wasn't clear that that could ever happen until the New Jersey Supreme Court said that it could. It was in 1990 when the US Supreme Court in the Cruzan case said, these are questions of state law. And whatever the state law requires is what, in fact, is required within the jurisdiction of that state. There are not constitutional rights which are going to overcome at least most state laws, and state laws govern. And that led to a focus on state laws on healthcare decision-making. And it led primarily and clearly to the Uniform Healthcare Decisions Act, a uniform law presented and adopted now by many states and adopted in part by almost all the states. But the first state to adopt the Uniform Healthcare Decisions Act was New Mexico. And that statute was the first law, the first written law passed by a legislature that said every person has the right to discontinue any treatment under any circumstances. So in fact, it provided clearly a clear articulation of rights that no one knew if anybody had before. And it protected patients who some thought might be caught in this terrible, unfortunately extended life, inappropriately extended life. Now, around the same time all this was going on, that New Mexico adopted the Uniform Healthcare Decisions Act, as it's the first state to adopt that act, and adopt very liberal principles in allowing patients to decide what kind of healthcare they wanted. Other states were experimenting with other ways of addressing issues at the end of life. And Oregon, through a vote of its population, adopted the Death with Dignity Act, as it was called in Oregon, which provided for medical aid in dying in Oregon. It went into effect finally about the same time that the Uniform Healthcare Decisions Act went into effect in New Mexico. And medical aid in dying provides that a prescriber can prescribe a lethal medication to a terminally ill, competent adult, so that terminally ill, competent adult can ingest it to end his or her life. It's very limited remedy, but it addresses some of the kind of problems that were really on everyone's mind starting in the 1950s and 1960s. That became clear starting with the Quinlan case. The Oregon experiment, it took 2 or 3 years of litigation before that new Oregon law, the Oregon Death with Dignity Act, actually went into effect, but it was generally considered successful. It brought peace to many people who used it. It brought peace to many people who didn't use it, but lived in Oregon and knew that they could. And it became a model for I would say, the more progressive states and the more libertarian states in the United States, states mostly in the West. And so now, 20 years after Oregon, more than 20 years after Oregon, after the Oregon laws become effective, after 10 other jurisdictions adopted medical aid in dying and have been implementing aid in dying, after several thousand cases, reported cases of compliance with the law and the prescription of lethal doses, it's coming to New Mexico. And that's what today's discussion is about. And so let me hand this over to Debbie and to Nick to tell us exactly what we have in New Mexico, how it's similar and how it's different from the law in Oregon and in other states.
Thank you, Professor Schwartz. I'll just make a couple of comments about how we differ, and then we can, you'll see that when we go through the law, when Nick does that. But we looked at Oregon and other states' laws, and also knowing New Mexico, tried to address what seemed to us to be artificial barriers and not practical for fitting in New Mexico. And one of the major barriers is a waiting period that Oregon has someone request in writing to their doctor, and then has to wait 2 weeks and then request it again in writing. And then they start the process of assessment and consultant and so forth. And as a result, it takes a lot longer than just a couple of weeks to go through the process. And in fact, takes more like 4 to 6 weeks. And Oregon and other states who have that waiting period have found that a lot of folks actually pass away before they can get through the process of obtaining the medication. So that didn't make sense to us and seemed pretty arbitrary. So we eliminated that waiting period between asking, and what we did maintain a 48-hour hold on the prescription, on filling the prescription, but added a waiver of that waiting period should the prescriber feel that in all likelihood the individual won't survive even the 48 hours. And as many of you know, a lot of people don't even get on hospice until the very end, days or weeks before their death. And so we did not think that the waiting period was appropriate. So that's different in our law. Secondly, we have a long history of practice, independent practice by nurse practitioners. I'm not exactly sure on this, but I think we were one of the first states, if not the first state, to have independent practice of nurse practitioners. Our physician assistants are pretty darn close, and we have loosened that up even more in the recent years. And for many people, those are their primary physician providers who they have the closest relationship with. And in communities around, rural communities around New Mexico, sometimes they're the only provider in the community. And so we didn't think it was right to exclude them if they're the ones that have the relationship and they have the full legal authority to prescribe the kinds of medications that we're talking about. So we added nurse practitioners and PAs under a certain circumstance, which we'll talk about. But that's different than anywhere else. We're the first in the country to do that. Secondly, we do ask for there be a secondary confirmation of by a physician of the terminal illness, but recognizing that if someone's in hospice, which most people are in the experience of other states, the vast majority, well over 90% are in hospice, they've already gone through a process of medical review and affirmation of that terminal illness in order to qualify for hospice. So we have said if the prescriber is a physician and they're in hospice, no other consult is required. So that is a big difference in other states as well. That hospice exception to a consult is different than other states. And lastly, in talking about the right kind of providers, we have said that, and you'll see in the law, if there's any concern about mental capacity to make this end-of-life decision, they have to be referred to a mental health professional. Some states have that they have to go to a psychiatrist to get that affirmation. Well, you all know psychiatrists are not, are few and far between, hard to come by, hard to get into here. And so we thought it was more appropriate to, consistent with our practice and under the Uniform Healthcare Decisions Act, that there are other mental health professionals who have the ability to determine capacity, decisional capacity. So that definition is much broader than just a psychiatrist, and that's different. And what we have found in doing this is that other states are now saying, oh, well, if New Mexico can do that, that's always been a problem. Other states are looking at amending their laws or changing their bills to do some of the same things that we're doing. So I think we have I think it's a good model. But with that, I'm gonna stop and turn it over to Nick to actually go through the requirements in the bill. And Nick, when you get to self-administration, I'd like to make a comment on that.
Sounds great. Thank you, Representative Armstrong, and thank you, Professor Schwartz. Truly an honor to present with you on this this piece of legislation and now law that has truly been in the making for decades. Thank you to everyone who has attended today. I'm going to go through, I have a PowerPoint I'll be sharing. I'm going to go through it relatively quickly so we have plenty of time for questions. And certainly if it will be sent out to everyone, so you'll have an opportunity to review it on your own time if we go through it quickly today. So to get started, I wanted to talk first about the definitions very briefly. So medical aid in dying simply means the medical practice wherein a healthcare provider prescribes medication to a qualified individual who may self-administer that medication to bring about a peaceful death. Most of what we'll talk about today will be focused on how someone becomes qualified and what criteria must be met for someone to qualify for medical aid in dying. Healthcare provider is defined in the Act is a licensed physician, licensed DO, advanced practice nurse who is licensed, or a licensed PA who can prescribe the medication used in medical aid in dying. And self-administer, as we'll talk about in more detail in a moment with Representative Armstrong, means taking an affirmative, conscious, voluntary action to ingest a pharmaceutical substance.
And if I can jump in here, that is purposely a little vague because it doesn't, self-administer does not say or intend to be completely independent necessarily. But there does have to be an affirmative, conscious, voluntary action so that it is in the control of the patient. But someone may need help, certainly need help mixing the drugs together when it's time, maybe holding a glass or some assistance like that. So it doesn't mean completely independent. It also doesn't say swallow, it says ingest. And the practice in other states is relatively creative in trying to address issues where someone can't swallow anymore or has a swallowing difficulty, but otherwise it has some volitional ability to control this. So it could be through a feeding tube. And there are some developments that we've heard in other states of rectal, so like with an enema type administration. So ingest, and we've had a lot of discussion with professionals in other states, means taking it into the gastrointestinal tract. What's really clear, and it's clear in the law, is there's no injections or IV. It is into the gastrointestinal tract, so that the word ingest is purposeful there. Thanks.
Thank you, Representative Armstrong. So in Section 3 of the Act, there are several required determinations that must be made by the prescribing healthcare provider. And for purposes of this presentation, I've broken them down into 8 specific requirements. They aren't necessarily broken down into 8 specific requirements in the Act, but when you read through Section 3, there are in fact 8 requirements. So first, the prescribing healthcare provider must determine that the patient has capacity, a terminal illness, that the patient voluntarily made the request, and that the patient has the ability to self-administer the medication as Representative Armstrong explained. And a note on capacity. So capacity under the Act is defined as an individual's ability to understand and appreciate healthcare options available to that individual, including significant benefits and risks, and to make and communicate an informed healthcare decision. And looking at terminal illness, it is defined under the Act as a disease or condition that is incurable and irreversible, and that, in accordance with the prescribing provider's medical judgment, will result in death within 6 months. The second requirement is that the prescribing provider must have provided medical care to the individual in accordance with accepted medical standards of care, which should not be a surprise to anyone on this Zoom. The third requirement has a number of elements, as you see here. So the prescribing provider must determine that the individual is making an informed decision after discussing with the individual their medical diagnosis and prognosis, potential risks associated with self-administration of the medication, probable result of self-administering the medical aid and dying medication, and also discussing the individual's option of choosing to obtain medical aid in dying, and then deciding not to use it, which, as I believe Professor Schwartz hit on, is an option that does provide comfort to patients. And lastly, the feasible alternatives need to be discussed with the patient, including concurrent or additional treatment opportunities that like hospice care, different palliative care, focused on relieving the symptoms and reducing suffering. The fourth requirement is that the prescribing healthcare provider must determine in good faith that the individual's request does not arise from coercion or undue influence. We can go into further in depth on that point in questions, but I think most of the healthcare providers are familiar with the signs to watch for to ensure that there's no type of undue influence or coercion. Requirement number 5 is that the prescribing provider must note in the individual's health record the prescribing healthcare provider's determination that the individual qualifies to receive medical aid in dying. Requirement number 6, the prescribing provider must confirm in the individual's health record that at least one physician or DO has determined, after conducting an appropriate examination, that the individual has capacity, a terminal illness, and the ability to self-administer the medical aid in dying medication. And I have to emphasize as we're going through this, all of this documentation is very important. One, to comply with the Act, but two, to really document for, if there is an OMI investigation that is done, so that they can easily see that this was a death pursuant to the Act, and therefore one in which the OMI does not have jurisdiction over. So the documentation aspect of this is very important. And the one note here is that the physician making the confirmation may be with the prescribing healthcare provider, the individual's hospice healthcare provider, or another physician who meets the requirements of that subsection. Now, the 7th requirement is that the prescribing healthcare provider must affirm that the individual is either enrolled in a Medicare certified hospice program or eligible to receive medical aid in dying after the healthcare provider has referred the individual to a consulting healthcare provider who has experience with the underlying condition that has rendered the individual terminally ill, and the consulting healthcare provider has examined the individual reviewed the individual's relevant medical records, and confirmed in writing the prescribing healthcare provider's prognosis that the individual is suffering from a terminal illness. The last requirement, requirement number 8, is that this form, which I've provided, this text comes directly from the law itself. It's actually written into the statute. So the provider must provide this form or a substantially similar form to the individual for them to complete. And as you can read on your own, this is really affirming a lot of the information we've discussed, and the patient understands really what has been explained to them and what they are agreeing to. And then there is this next, this page, a signature form really, which requires the patient to sign it, and then also requires the declaration of 2 individual witnesses. And with regard to those witnesses, no more than 1 witness shall be a relative by blood marriage or adoption of the person signing the request, which is the patient agreeing to medical aid in dying. And no more than 1 witness shall own, operate, or be employed at the healthcare facility where the person is signing the request. Now, when it comes, so those are the 4 major requirements that a healthcare provider must complete under the Medical Aid in Dying Act. But there's also several other sections that we need to pay some attention to today. One is Section 4, which deals with how to determine capacity. And in Section 4, if an individual has a recent history of or is currently experiencing a mental health disorder or an intellectual disability that could impair their judgment regarding end-of-life medical decisions, the individual cannot and shall not be determined to have capacity until the healthcare provider has referred the individual for an evaluation by a mental health professional with the training and experience to assess a person with such a disorder or disability. And then after that is done, the mental health professional must determine that the individual does in fact have capacity to make end-of-life decisions. And mental health professional under the Act is defined as a state licensed psychiatrist, psychologist, master social worker, psychiatric nurse practitioner, or professional clinical mental health counselor. As Representative Armstrong briefly mentioned, in other states there are varying waiting periods, and there is a waiting period with one exception in New Mexico, and that's in Section 5 of the Act, which provides that any prescription for medical aid in dying shall not be filled until 48 hours after the prescription for medical aid in dying has been written. And then it goes on to state that the prescription itself for the medical aid in dying medication must indicate the date and time that the prescription for medical aid in dying was written, and it must also indicate the first allowed date and time when it can be filled. There's one exception to those requirements, the 48-hour waiting period, and that is if the qualified individual's prescribing healthcare provider has medically confirmed that the qualified individual will likely and within reasonable medical judgment die before the expiration of the 48-hour waiting period. In that instant, the prescription can be filled once that the prescribing provider affirms all eight requirements have in fact been met. Now, the right to know section 6 of the Act states that a healthcare provider shall inform a terminally ill patient of all reasonable options related to the patient's care that are legally available to terminally ill patients that meet the medical standards of care for end-of-life care. Now let's talk about liability protections. One notable thing about this Act is not only does it provide protections for patients, but it also provides a significant number of protections for providers. First, it states that a person shall not be subject to criminal liability licensing sanctions, or other professional disciplinary action for participating or refusing to participate in medical aid in dying in good faith compliance with the provisions of the End of Life Options Act. Or that also applies to someone who's present when a qualified patient self-administers the medical aid in dying medication. Now, a healthcare entity, professional organization, health insurer, CMO, or individual healthcare provider cannot subject a person to censure, discipline, suspension, so on, any type of denial of licensure or credentials, or other penalty for participating or refusing to participate in the Medical Aid in Dying Act. Now, moving on in this section, so Section 7 deals with conscience protections for providers. And under the Act, no healthcare provider who objects for reasons of conscience to participating in medical aid in dying can be required to participate. So they can, healthcare providers always have the option of exercising their right to object based on conscience. In the event that they do so, there are necessary steps that have to be followed. And those are in that second bolded paragraph there. And essentially, the healthcare provider must inform the individual and refer the individual to a healthcare provider who is able and willing to carry out the individual's request, or to another individual or entity who can assist the requesting individual in seeking that medical aid in dying. Now, there are prohibited actions, and those prohibited actions state that a healthcare entity shall not forbid or otherwise sanction a healthcare provider who provides medical aid in dying off premises of a healthcare entity, or when the healthcare provider is not acting within the normal course and scope of the healthcare provider's employment. So those are instances where a healthcare provider cannot be sanctioned for performing performing an act under the Medical Aid in Dying Act. And then there's a certain permitted action regarding what a healthcare entity can do. And it states that a healthcare entity may sanction a healthcare provider for participating in medical aid in dying on the premises of the prohibiting healthcare entity only if the entity has given written notice to the healthcare provider of their policy prohibiting participation in the medical aid in dying, and the healthcare provider participates in medical aid in dying on the premises of the healthcare entity or within the course and scope of their employment. So if a healthcare entity decides that they don't want to participate, that is what they must comply with. They must be giving written notice to the healthcare provider of that policy. And then those other two criteria must be met before any type of sanction could be levied against the healthcare provider. There are additional protections set forth in Section 7. First, a healthcare provider, the Act itself prevents a healthcare provider from participating in medical aid in dying while acting outside the healthcare entity's premises or outside the course and scope of the healthcare provider's capacity as an employee or an individual who seeks medical aid in dying from contracting with the individual's prescribing healthcare provider or consulting healthcare provider to act outside the course and scope of the provider's affiliation with the sanctioning healthcare entity. So those are prevented, or nothing in the End of Life Options Act prevents either of those actions. Now, if there is a situation where sanctions are going to be imposed by a healthcare entity, those sanctions or the entity imposing the sanctions shall act reasonably, both in the substance of the sanctions and the procedure leading up to the sanctions. And the sanctions shall neither be arbitrary nor capricious in its imposition of sanctions. Now, what must a healthcare entity do to prohibit medical aid in dying? So if a healthcare entity wants to prohibit medical aid in dying, it has to accurately and clearly articulate its position on any website maintained by the entity and in any appropriate materials given to the patient to whom the healthcare entity provides healthcare in words that can be determined by the healthcare entity. But to be very clear, if a healthcare entity does want to prohibit medical aid in dying, those criteria must be complied with. Now in Section 8, it deals with prohibited acts under the End of Life Options Act. And so nothing under the End of Life Options Act shall be construed to authorize a physician or any other person to end an individual's life by lethal injection, mercy killing, or euthanasia. That is strictly prohibited under the Act. And actions taken in accordance with the Act shall not be construed for any purpose to constitute suicide, assisted suicide, euthanasia, mercy killing, homicide, or adult abuse under the law. There are certain reporting requirements. The Act directs DOH to promulgate and adopt reporting rules, which at a minimum must include the list of reporting criteria there, 1 through 6, that you will have access to when you get this PowerPoint. And the Department of Health will prepare an annual report, a statistical report based on the information that's reported by healthcare providers. So I know that was incredibly fast. I apologize for going through it quickly, but you will have the PowerPoint that you can review, and I think it will be very beneficial to have a discussion with Representative Armstrong and Professor Schwartz regarding all of the provisions we've talked about. So if anyone has questions, now is a great time to ask them. But of course, if you are unable to think of your question or we don't get to it, we can address it offline also. But please, any questions you have now is a great time to ask them.
Hey, Representative Armstrong and Professor Schwartz, can I have to ask a question about why you statutorily define this as non-suicide?
You know, I think it is important, and we talked with many psychologists and so forth as well, that suicide is usually an act taken in isolation out of desperation for a situational desperation and often violence. This is different in that it is planned with family and loved ones in a situation that is not reversible. And so it's not done in the same context that we think about suicide. It's also then important that that flows all the way down to death certificates and the ability to not have any impact on life insurance and contracts and so forth, that it is not considered suicide in the same way that we generally think of suicide. It is just hastening the death of that would otherwise be inevitable due to a underlying terminal illness.
Let me add a little bit to that, because I thought a lot about this question too. Why do we care whether it's called suicide? Why does anyone care whether we call it suicide or not? Because it really makes no legal difference. I mean, the consequences in terms of, for example, insurance policies is almost nil. You really don't see policies which consider that in a meaningful way. It really is the emotional consequence on the individual and the family of calling it suicide. And the consequence that has on the decision making for those patients. And you want those patients to be able to think about this as another option that's available to them and if you call it suicide, that term is so freighted, has such terrible consequences, I think, in their minds, that it changes the nature of the analysis that many of us do. So I think it's a hard question, though, that you ask. But I think that that's one of the reasons that at least many people have been so careful not to define this as suicide. Early on, there were worries that, in fact, if this were suicide, it would also affect, for example, the right to inherit, the right to receive proceeds under insurance policies, and other issues. But we wanted to make, I mean, of course, we want to make sure that that doesn't happen, but I don't think that that's the primary issue anymore.
And related to that, there's a question in the chat about the death certificate, and we hope that there's more specific guidance or training coming out from Vital Records at DOH or OMI. But the discussion we've had is this will be classified as a natural death cause of which is the underlying terminal illness. Professor Schwartz, do you want to address the civil immunity? We've had that question a couple of times. I'll start by saying some things we had in the law because we thought it was clearer to have it included, but in the sausage making of legislation and negotiating with other legislators to keep it moving and pass, sometimes we had to negotiate a few things out, this being one, but decided that it wasn't particularly meaningful in the place and context in which it was in the original bill. I'll let Professor Schwartz.
And I can add just a little bit to that too. And you can see what Representative Armstrong is talking about if you look at the conscience clauses too. We say everything 3 times in those conscience clause provisions because we want to make it very, very clear what the rights are of those who want to opt out. And we want to make it clear that those rights apply to those who want to opt in as well. This, unlike the statutes in other states, this protects people who want to participate in aid and dying as well as those people who don't want to participate in aid and dying. So it was really important for us to make sure that that was clear. And as a result, we repeated it many times. We followed the language in the earliest statutes, the Oregon statute and others, when we originally drafted this by putting in the limit on civil liability as well. The chair of the Senate Judiciary Committee, who is a very thoughtful legislative drafter, was really behind taking it out of this bill. And his argument, as I understand it, was it's completely unnecessary. And he said he was thinking, I believe, as I read it, he was thinking, what you say is you're not liable for participating in aid and dying, and you're liable for participating, and you're not liable for participating, and you're not liable for not participating. So nobody who treats a patient at the end of life will ever be liable for anything. And he said that wasn't the intent, clearly not the intent of the statute. The intent wasn't to take away legal liability for negligence that would otherwise be there. So in fact, it's clear, he thought, if we left off that limitation on civil liability. There's still no civil liability without proving negligence. The traditional rules of negligence, which apply throughout the rest of healthcare, would apply when you're treating a patient at the end of life as well. But they're no different, they're no more severe, and we wouldn't expect there to be any liability. Again, there is no real sense that there is any interest in liability in other states, in part because the damages would be very small, and in part because there is, I think that the courts are beginning to realize and recognize, a few have in the last year, that there's the problem of not allowing this kind of care may be at least as great as the problem of permitting this kind of care. So really what the senator was doing, I think, in removing that section on civil liability was just returning us to the basic rules of civil liability. Those rules still are in place and still apply.
Thank you. I've been answering a question about the pharmacies. It's a compounded medication, and so that alone limits the pharmacies who would participate. We've identified about 5 in the state who are willing. Some states only had 1 or none when they started. The medications can be overnighted, so that's doesn't have to be a local pharmacy. And different states treat it differently, and I think by provider or patient and pharmacy can come to agreement. So we have been talking about this. Some pharmacies, even though it's past the 48 hours, don't actually ship the medication until the patient says they're ready, so that they don't have to worry about storing it at home, keeping it safe, or getting rid of it if they don't utilize it. Others send it to the patient, at the patient's request, and they have it, and then if they're on hospice helps assist patients or families. It's not the patient anymore, families, to appropriately dispense of medication. But that's something that we hope to address also with the pharmacist, about full instructions included with it about how safe storage and disposal. And again, that's the disposal part won't actually be for the patient. It'll be for family after the patient has passed.
And yes,
go
sorry,
ahead.
go ahead, Representative Armstrong, go ahead.
I was just going to add on to that. Currently, there's not necessarily insurance coverage for the medications. Different states have had different experience with some covering, some not. I think California Medicaid may even cover. We've not had those discussions with anyone here. And so in most places there's not coverage. So the assumption should be that it's private pay for the medications, which I think the cost is anywhere from about $800 to about $1,500, depending on the formula and where you're getting the medications.
My apologies for the power mowers, which have just started immediately outside my window. I hope that they don't come through at least too clearly. Let me just answer a couple questions from Dr. Brillman. There's no need for the New Mexico Medical Board to allow physicians to participate. It is part of the practice of medicine now in New Mexico, or it will be on June 18th. And it will be like any other new form of treatment that would be available. Of course, no one's obliged to participate in it and to provide aid in dying, but for physicians who wish to, it at least will be available. Let me also point out that there is no plan to have a central registry of physicians who will participate. We hope that the End of Life Options New Mexico, an advocacy organization, will help patients who need to find appropriate physicians for their conditions. Will help them find physicians who will talk to them about these options. But there's no plan for a formal central registry, and there are good reasons, I think, not to have a formal central registry of physicians who engage in this kind of form of medical practice. And finally, let me just add to what Representative Armstrong said with regard to the drugs that are dispensed. They'll be treated like all other medications that are still in the medicine cabinet when the patient dies. That we hope in most cases the hospice workers will in fact dispose of them appropriately the way they dispose of other medications. This is not going to be, for most patients who have this medication sitting in their medicine cabinet, this is not the only medication they have in their medicine cabinet that will be lethal if someone happens to find their way to that medicine cabinet and take that medication. So this will go with all those other medications that really do need to be appropriately disposed of, and will be disposed of in the same way that those other medications are now.
And if I can add, if you're not going to participate, the referral mechanism that's required is not necessarily to another provider who will prescribe, but it can be to another person or entity who will assist that person. And so in New Mexico, there's been a coalition that's worked for quite a long time, literally meeting every month for the last 6 or 7 years, 8 years. The End of Life Coalition, and we're now a 501c3, End of Life Options New Mexico, and an End of Life Options NM. And I still have done it wrong in the so I'm going to do the correct website. And we are Barrick, maybe you can type it in while I'm talking. Intend to become the clearinghouse of information, a hub for referral, information for individuals, help for providers, getting you connected with other providers for education and training and support, information for families and communities. And so we will know and hope that others, that providers who don't want to participate, if they don't happen to know someone offhand, will refer to End of Life Options New Mexico, and we will assist them in finding someone to meet their needs. Let's see, I'm gonna try this again. endoflifeoptionsnm.org. And Annie, can you remind me of the other questions that you had ahead of time, whether we have addressed everything? And I'm scanning back through the chat as well.
Let's see.
I was just looking too at the questions we were asked ahead of time. There was some question about whether only those over 18 were eligible for medical aid in dying in New Mexico. In other states, adult is defined as someone over 18, and the statute begins, an adult may request. In New Mexico, we still define over 18, we still define adult as over 18, but the statute begins, an individual may request, not an adult. But the form signed by the individual, in fact, says, I am an adult, and you must use a form which is substantially the same as that form in the statute. And I think that from a legal point of view, that the word adult is a very important word. And if the form that is used by the patient does not include that word, and if there isn't evidence that the patient's actually an adult, it wouldn't be in substantial compliance with that section of the statute. So the statute is really limited to adults, and only to adults, only to those over 18, as I read it, and that would make it consistent with the statutes in all of the other states that have adopted aid in dying statutes. There was one other question. The question is, how can the physicians report whether or not the medication was in fact used as the physician seemed to be obliged to report, since in fact they may have no idea what happened once they prescribed the medication. How can the prescriber report on whether it was used or not? And I think that in fact all that the prescriber can do is provide the information that the prescriber has and that the prescriber knows. If in fact the prescriber knows that the patient who has been prescribed the medication used the medication and the date that it was used, then that information will have to be provided by that should be provided by that prescriber to the Department of Health. If the prescriber can't possibly know that, now if the prescriber has for some reason lost contact with the patient after the prescription, then the prescriber can simply provide that information to the state. We're waiting for the state to provide additional forms that will be report forms that will make it much easier for providers to actually file the required reports. We don't have those forms yet, but there's no possible way that prescribers will be required to provide information that they don't have.
And that was a good question, because we will follow up with Department of Health as they're putting together rules. And of course, it's a rulemaking process, so public comment and so forth will be required. But to clarify on that particular issue, and I envision something like that in reporting, that you can designate, did you witness, or was it reported to you, and by whom? Or do you not know? And so we can, I think in the rulemaking process, we'll have more clarity. Barrick, did you have a thought?
I did. Just before we wrap up, because I know time is getting short, I just wanted to introduce myself, Barrick Wolf, a longtime participant with the others that you see around this call and many others who maybe aren't on today, in advocating for this new law. Now that it's passed, we are moving forward with all due haste to try and position ourselves to be able to support the implementation. And this is probably the first of, well, it's not even the first, but it's one of many early interactions we'll be doing. We're on the agenda for the Hospital Association and the home health and hospice folks. It's going to take some time to get the word out and to do this kind of training. And I just wanted to sort of reassure folks that this is not, it may be sort of the first with the Medical Society, but I'm sure hoping, Annie, that it's not the last, that this is going to be an ongoing conversation and a dialogue. We have a law that's a framework and it has legal implications, but we also have the practice. And that practice has been going on for years. Judith Brillman, who is on our implementation committee, has just put into the chat an address for a terrific national organization that has come up in the last year and a half to begin to collect the experience from the prescribers across and the entities across the country that are doing this work. And it's sort of developing best practices and guidance. They will be involved in coming out or Zooming and doing the training that needs to be done with hospices, with clinicians. And I just wanted to sort of humbly let you know that we're here to support this law, and we're going through that process now to organize, as a good number of states have done, Washington, Oregon, and others. And next week, as we get into our more clinical-oriented panel, again, it will continue to be an introduction. There's just too much to cover in 1 hour, but it'll give you more perspectives on how clinicians think about this, how health systems are thinking about implementing it, and the experience nationally, again, from a very fine national physician who's been working these issues for 20 years. So again, just wanted to appreciate the opportunity for our End-of-Life Options New Mexico to participate in this forum today.
A couple of follow-up things in the chat. Hospices have been involved. That we have some hospices that have been active and supportive, and others that stay neutral. We have been for years now having conversations with the association in their conferences, and have had hospice nurses and providers involved with us on advocating for this. So that's been good. I would also wanted to mention the Judith Brillman, when she put the website in there for the American Clinicians Academy of Medical Aid in Dying. They also have available on their website for free continuing medical education on aid in dying, and agree that Nancy Gwynn mentioned, we hope that as our organization, End of Life Options New Mexico, moves forward, that we do have a fundraising capacity to have funding support for individuals who can't afford the medication. That's not something we have out the gate, but it is something that I hope that we will have in the future, and we might be able to also partner with some other foundations to be able to do that. There was a question about the prescriptions being part of the New Mexico PMP monitoring program. Hospice is excluded from that. So if someone's on hospice, no. If they're not on hospice, and again, we anticipate very few will not be on hospice, but if they are not, then I expect you do have to do that, because this hasn't been contemplated before by that monitoring program. So that's a good question, but for most, it's not going to be an issue. And then there was a question about if you can mention this to patients versus wait for them to ask. The right to know section of this says that healthcare providers, and as defined in the Act, which is physicians, nurse practitioners, and PAs, if they have a terminally ill patient, need to discuss all legal and relevant options, reasonable options with their patients. How and when you do that and how you do that with a patient is not defined in here. The medical art of practicing medicine is not defined in here. So your standard of care and so forth, we have not we purposely have not dictated medical practice in the act. But there is an expectation that you'll discuss all options with patients.
And let me just add to what Representative Armstrong just said, because those are two really important questions. Dr. Agostini's point that really there's a very substantial health equity issue, if in fact only the very wealthy are going to end up having access to this, is really significant. And it's one that's really important, I think, to everyone across the state. And I hope that we'll be able to address that over the next several weeks. The second issue is, as Representative Armstrong said, this is unlike other states. In some states, the patient must raise aid in dying. That was an early version of these statutes. That is not the law in New Mexico. It's quite the reverse, that when in fact there is a terminal diagnosis, the burden is on the physician to do what a good physician would do under those circumstances, what a good provider would do under those circumstances, and in fact to raise reasonable medical alternatives for the patient. And if this is one of the reasonable medical alternatives, then the healthcare provider has an obligation to raise this issue.
A good observation also, no federal funds can be used for this. So that is a question to work around VA or federally qualified health centers and so forth. So we are discussing those issues, and many other states get around those things in other ways, but the federal funds, so Medicare, for instance, or Part D plan is never going to pay for the prescriptions.
But
and
Medicaid,
Medicaid could with using state funds, segregated state funds.
Great. Well, I think our time is a little bit over. Thank you so much, everyone. Representative Armstrong, Professor Schwartz, Nick, all of the participants online. Remember, if you are looking for CE for this program, please make sure that your name and email is in the chat room. We will be able to get this. We've recorded this, so we will provide the recording and the PowerPoints to participants. It looks like Hussein, do you have your hand up?
No, those are clapping. Those are clapping hands.
Oh, thank you. Sorry about that.
And please join us for part 2, which will be more
Yes.
clinically oriented.
Yes, we've got part 2 next Thursday, same time, same place. So I hope to see you all there. Thank you.
Thank you.
Thank you.
thanks so much. Good to see you all.
Thank you, Professor Schwartz, Representative